This program is brought to you by the Practicing Law Institute, a nonprofit learning organization dedicated to keeping attorneys, professionals, and accountants at the forefront of knowledge and expertise.
In case you haven't noticed, digital assets, including cryptocurrencies, have experienced explosive growth in recent years. Last November, Time magazine reported that the cryptocurrency market is now worth more than $3 trillion. That's up from $14 billion just 5 years ago. Surveys indicate that around 40 million Americans have invested in, traded, or used cryptocurrencies. Still, the crypto regulatory environment remains a bit murky. On March 9th, President Biden signed an executive order that calls on federal agencies to take a unified approach to regulation and oversight of digital assets. According to CNBC, the long-awaited directive has had the crypto industry on edge, not least due to growing regulatory concern around the world surrounding the nascent digital asset market. We want to unpack President Biden's executive order and figure out what it could mean for the crypto industry. And we have two experts on board to help us do that. Carla Caraveau, who is the Chief Legal Officer of CoinList, and Michael Liftik, a securities regulatory and enforcement partner at the law firm Quinn Emanuel. Join the crypto conversation today on Insecurities.
Hello, and welcome to the Insecurities Podcast, keeping it fresh and staying wonky on the latest securities, regulatory, and enforcement developments with a practitioner's perspective on the stories you should be following. As always, I'm Chris Ekimoff, and I'm here with my co-host, Kurt Wolf.
It's good to be with you again, Chris. You know, I love it when our episodes address hot topics that are playing out in the real world in real time, like the topic we're talking about today.
Fresh and wonky.
Fresh and wonky, absolutely right. It is a timely topic for our listeners. We are going to be talking crypto. Of course, this isn't the first time we've talked about cryptocurrencies, digital assets, distributed ledger technology, and initial coin offerings here on Insecurities. Listeners, you can always go back to episode 15 to hear our conversation with Teresa Goody-Guillen, Usman Sheikh, and Jason Somonsato about everything from DLT to ICOs. But the digital assets and crypto space continues to be a hot topic, and the executive order on ensuring responsible development of digital assets, which is just a couple weeks old now, is certainly one of the most talked about developments in the space. I'm excited to have Carla and Michael on the show today to help us make sense of the order and peek around the corner with us to get a sense of what might be coming down the road. The big question we want to answer today: will the executive order on ensuring responsible development of digital assets bring order to the regulatory chaos for crypto? We got a lot to cover. So, Chris, why don't we get started with some introductions?
Yes, I'm proud to give a little bit of background on Carla Caraveau, who is the Chief Legal Officer of CoinList, a platform that offers tools for early adopters to trade and earn digital assets, which we'll be discussing in a little bit more detail as the episode unfolds. Carla focuses on leading legal strategy in emerging technology industries. In addition to her role at CoinList, Carla is the board president of Biotech Partners, a nonprofit focused on facilitating biotech careers for underserved youth in the Bay Area. Carla also serves as an advisor to Compliance.ai, a RegTech platform, and is director and advisor to Caplay Technologies, Inc., an alternative assets platform specializing in derivatives. And in a previous life, Carla served as senior counsel at the SEC, where she worked in a number of roles, including as a top government affairs aide to former SEC chair Mary Jo White. Carla, welcome to Insecurities.
It's a pleasure to be here. I love the name of your podcast, and it's great to be working with Michael again.
Thanks. And that's a perfect segue. I am very pleased to introduce my friend and colleague at Quinn Emanuel, Michael Liftik. Michael is a co-chair of our SEC enforcement practice, where he advises public and private companies, senior executives, financial services firms, and funds in government and internal investigations, regulatory enforcement, defense, and securities litigation. Michael also devotes a significant portion of his practice to the digital asset space, where he advises exchanges, issuers, and other developers in SEC inquiries and above-the-fold crypto litigation. Before joining Quinn Emanuel, Michael served as the Deputy Chief of Staff of the SEC and as a Senior Legal Advisor to Chair Mary Jo White. He also served as the SEC's representative on the Financial Stability Oversight Council, the FSOC, which we're going to hear a little bit about later. Michael also led the SEC's initial efforts to identify areas where fintech intersects with securities regulation, and he drove the SEC's very first FinTech Forum. Michael, it's good to have you on the show. Welcome.
Thanks, Kurt. Thanks, Chris, for having me. And Carla, agree. Nice to be working with you again.
All right, so that's pretty high-level background for both of you, but we want to hear a little bit more about your experience. Carla, let's start with you. Tell us about some of your experience in the fintech space and some of these leading technologies, and tell us a little bit about CoinList.
Yeah, well, maybe I'll just start with CoinList because it's got such an interesting story. We were born of this idea from Protocol Labs. They are the project team that started Filecoin. And so for those that don't really follow this space, Filecoin is kind of a storage provider using distributed ledger technology. And so Protocol Labs came to AngelList, and AngelList is kind of the storied institution here in Silicon Valley that brought together entrepreneurs and investors and really, I think, created this environment where Silicon Valley exploded. And they had a big hand in like regulation, crowdfunding, and the Jobs Act and that kind of thing. So anyway, Protocol Labs comes to AngelList and says, hey, we want to do a compliant offering of our token. And that's how the idea for CoinList was born, was like, how do we do this compliant offering of a SAFT under Reg D? And so CoinList did the KYC, they ran all the AML checks, and there was a real need in the industry at the time, and still continuing, for good actors in this space, people that wanted to do the right things in a compliant way. And so people just started gravitating towards CoinList for that. And we've just grown and grown and grown. So now that, we have a trading desk, we have an exchange. We raised $100 million last quarter, or the end of 2021. And we're using that for global expansion. And it's all based on this idea that we're helping the best projects succeed, and we're trying to do it in a compliant way. So I love being at CoinList, and I love the mission statement of CoinList. When I was at the commission and really working with Michael and Mary Jo and others, we were trying to figure out, like, how do you allow things, to move forward in a good way, be innovative, but also think about things like consumer protection. And I feel like CoinList is exactly that. And then just generally, when I left the commission, I started, thinking about what's not happening in this industry, in fintech generally. And honestly, it was just regulators unable to talk to the entrepreneurs, unable to understand where they were coming from, and vice versa. And so I'm hopeful that I'm a little bit of a bridge there. And that's kind of my career goal anyway.
Michael, we talked a little bit about your background up top, but, your practice in the digital asset space, I'm sure, has evolved with the clients you've worked with over the past few years. Any war stories you can share, or maybe talk a little bit about that progression?
Yeah, that's a great question, Chris. And as Carla alluded to, I've been thinking about crypto and crypto regulation since about 2013, when the SEC first started trying to wrap its arms around, gosh, what is this Bitcoin? What do we need to be thinking about? And the evolution as it learned about more and more digital assets and distributed ledger technology and its potential implications for consumers, for investors, for markets. Since I've been in private practice at Quinn Emanuel for about 5 years, a decent chunk of my practice has always constituted working with various digital asset platforms. And there has been an evolution. Starting in 2017, 2018, a lot of the action was around ICOs. And you saw as various platforms struggled to figure out the right way to do some kind of an offering. Was it through a Reg D, a Reg A, or a Reg S offering? Was it to take the position that the assets weren't securities, and so there is no need to comply with those regulations through a utility token, and grappling with those issues? As the space has evolved, you see more and more digital asset platforms are focusing on decentralization and trying to figure out, how do they raise money early stage, be still yet connected to a token, and then when they launch as near as you can to a decentralized state. that obviously poses its own challenges. The phrase I'm using these days is, there's no such thing as the virgin birth of a token, except for maybe Bitcoin. And so somebody's got to be behind these platforms. And how do you advise compliance with the federal securities laws and other regulations? And then what we're seeing more and more as our practice has evolved from a pure regulatory defense, SEC actions and others, investigations, to a counseling role where companies are recognizing that they need to get this stuff right at the beginning rather than wait for defending themselves when it's sometimes too late. So we increasingly are doing more and more upfront counseling and helping digital asset players, layer ones, exchanges, et cetera, structure their business in a way that's attempts to comply with the various regulations. And there's the challenge, right? And then I think we're going to get into it, is it's a very hard area to advise because I've been very outspoken, and others have been as well, that the SEC and other agencies have not provided sufficient guidelines or guardrails as to how to conduct, other than, essentially a we'll let you know when we see it type of approach. And it's worth mentioning that the other area that emerges in this space is increasingly more private civil litigation. So as the SEC has brought more and more cases, you're starting to see the plaintiffs bar realize that there is essentially a follow-on action that they can bring for any unregistered securities offering. And so there are more and more class actions being brought, both in the Southern District of New York, in California, elsewhere, and we're very heavily involved in defending several of those cases.
As we mentioned up at the top of this episode, Kurt, we want to dig into the executive order on ensuring responsible development of digital assets, or as no one in the market has called it, the EOERDDA. I think, Michael, you did a great job of just doing the background on some of the regulatory landscape for digital assets over the past few years. Carla, I'm interested in your perspective from that in-house seat. Do you think that there's a different take on the regulatory view from your position?
No, I mean, it's so challenging for us, and Michael laid it out beautifully. Here in the U.S., we as exchanges, we have the federal scheme to worry about, right? So we have certainly FinCEN and the IRS and the SEC and the CFTC, the CFPB even, but it bears emphasizing that we also have a myriad of state regulations and rules that we have to comply with, right? And all of those are different. And it's really challenging sometimes to make sure that you are walking the line across all of those different types of regulatory schemes. And sometimes, like with New York, they are actually harder than the federal schemes are. So, I think that we need to pay attention to that too. And also, we are very much focused here on the U.S. and the executive order is about the U.S. But as an exchange and considering this technology, it's an international focus, right? And this technology does not believe in borders. So we have to certainly pay attention to what's going on here, but it doesn't mean that we can let our guard down everywhere else either.
Thanks, Michael, and thanks, Carla, for setting the scene a little bit. I think with that context, we can go ahead and jump in and talk a little bit about President Biden's recent executive order. The backdrop, and these are my words, certainly not language in the executive order, is that the digital assets and cryptocurrency industry has for years existed in kind of a regulatory gray space. But the industry has gotten so large that the government needs to decide whether and how it wants to regulate the space. To that end, the executive order calls on a host of federal agencies to collaborate on a unified approach to regulation and oversight of digital assets. According to a White House fact sheet that describes the order, President Biden's directive is, quote, the first ever whole-of-government approach to addressing the risks and harnessing the potential benefits of digital assets and their underlying technology, end quote. The order sets out 6 key priorities. First, consumer and investor protection. Second, financial stability. Third, illicit finance. Fourth, U.S. leadership in the global financial system and economic competitiveness. Fifth, financial inclusion. And sixth, responsible innovation. To develop a unified approach in those areas, the order directs various agencies to assess risks, prepare reports, and develop policy recommendations. There are a lot of different takes on the order. For example, a senior fellow at the Brookings Institution called it, quote, more of a call to action than a specific game plan, end quote. We won't offer our views on it. That's what our guests are here for. So, Carla, let's come back to you. We'll talk a little bit about some of the details in the order in a minute, but high level, how would you describe the order? I mean, is this a research project or is this a regulatory reformation?
Yeah, that's a great question. I mean, I'm personally cautiously optimistic. I think the industry has differing views, but to me, it's a statement piece, right? We're recognizing finally at the presidential level that there is a legitimate asset class here. There's a market base that the government should and must pay attention to. A good friend of mine likes to say that you can't put technology in a box once it's out. It's just going to flourish. And so that's the executive order to me is kind of recognizing that maybe in a big way, the biggest way for the first time. And so as we start to move forward, I think we're not going to look back. So all of that is very positive. Some things I'll note about the fact sheet, it starts talking about the things that you already put in buckets, like protection for consumers in the financial system, security, and climate change. And those are first, right? And then it mentions a little bit about, benefits and innovation. But to me, that's instructive. If what we're looking for, in this executive order is like, how do we protect people? How do we protect the people that are going to use this technology? And then also it struck me when you're looking at this information that it's really about, how can this technology benefit the U.S. and not necessarily the industry itself? Mm-hmm. Looking at all of that, together, I think really it's about do we want, who do we want to regulate in this space? And then how does the U.S. adopt this technology? Because I think there's some recognition now that they need to.
Yeah, that's interesting. I was actually talking to a friend who is a practitioner in Canada and does some work in the space. And he was saying, it's going to be crazy if we start to see things coming out of the U.S. that are entirely U.S. centric. You need to play ball with the rest of the world because we're doing this stuff too. And crypto just sort of doesn't honor national boundaries, right? It's sort of everywhere at the same time. So it's interesting that this is kind of a U.S. focused order. But with that, sorry, I'm stealing everyone's thunder. Michael, I'd like to get your take, sort of high level. What do you make of this order?
Yeah, I mean, I would agree with how Carla described it. It is a significant first step. A lot of us who have been dealing on the regulatory side for some time now have been clamoring for clarity for a whole government approach, not just leaving it up to which agency can be the most aggressive at any given time to own the space. So it would be the height of cynicism to turn around and criticize the executive order up front. I'll do that maybe towards the end. But I do think that it is a recognition that this is there's a really wide waterfront to cover. The executive order tries to do that. I think, the topics that you listed there, Kurt, is fairly well encompasses almost anything you could think about. The question is whether the government really can execute on the broad mandate that the president set out for it. Can it really wrap its arms around all of these aspects at the same time? But I do think it is an important step, particularly as Carlos mentioned, given the international aspect of crypto. What you are seeing in the space now is the lack of certainty and predictability in the US is leading lots of projects to just simply deliberately stay offshore. There are many projects where if you go to their website, it'll say, sorry, you're in the US, you can't access this project. That's actually a very sound regulatory approach right now. Don't participate in the US because it's unpredictable what will happen. But obviously we have the strongest and deepest capital markets in the world, and we should not be excluding this novel, innovative asset class on that basis. So if this allows the government to signal, we're here, we're going to roll up our sleeves, we're going to grapple with it, and we recognize we've got to bring more clarity to the space, I think that's a good thing.
Yeah, I totally agree. But all that said, I don't think that there's going to be regulatory reformation anytime soon, right? I was at a payments conference recently, and there was a lot of regulatory representatives there, and they were like, we don't really understand what a national CBDC is trying to solve. And so the executive order, is assuming that there should be a CBDC. When you have people in an agency that don't have those same assumptions that this executive order is kind of like putting out there, it's clear to me that it's going to be really hard to get anybody to kind of have one view in one agency, but certainly across all the different agencies. So I think we're going to just be subject to a lot of different proposals and rulemakings in the hopes that in 10 years, we all have one view.
Yeah, Carla, you hit on a note, and Kurt, you brought it up as well. There's going to be a considerable amount of coordination and cooperation due to this executive order across regulatory agencies in that whole government approach. That said, I think I have a little bit of a confession to make. Kurt and I sometimes assign each other difficult segments of our podcast episodes based on side bets. And since his Richmond Spiders are this year's Atlantic 10's men's basketball champions, and my St. Bonaventure Bonnies didn't even make the weekend in that tournament, it's on me to list the agencies and government officials named in that executive order. Those are, in no particular order: the Secretary of State, the Secretary of the Treasury, the Secretary of Defense, the Attorney General, the Secretary of Commerce, Secretary of Labor, the Secretary of Energy, the Secretary of Homeland Security, the Administrator of the Environmental Protection Agency, the Director of the Office of Management and Budget, the Director of National Intelligence, the Director of the Domestic Policy Council, the Chair of the Council of Economic Advisors, the Director of the Office of Science and Technology Policy, the Administration of the Office of Information and Regulatory Affairs, the Director of the National Science Foundation, the Administration of the United States Agency for International Development, representatives of the Fed, the CFTC, the FTC, the SEC, the CFTC, the FDIC, and the Office of the Comptroller of the Currency.
Yes.
That's a lot. All right, now back to the regular take.
That's a lot.
If you could still see me, Kurt, I did not pass out.
Yeah.
It is on me to list the agencies and government officials named in the executive order. Those are the Secretary of State, the Secretary of the Treasury, the Secretary of Defense, the Attorney General, the Secretary of Commerce, the Secretary of Labor, the Secretary of Energy, the Secretary of Homeland Security, the Administrator of the Environmental Protection Agency, the Director of the Office of Management and Budget, the Director of National Intelligence, the Director of the Domestic Policy Council, the Chair of the Council of Economic Advisors, the Director of the Office of Science and Technology Policy, the Administration of the Office of Information and Regulatory Affairs, the Director of the National Science Foundation, the Administration of the United States Agency for International Development, and representatives of the Fed, the CFPB, the FTC, the SEC, the CFTC, the FDIC, and the Office of the Comptroller of the Currency. Michael, in your background, you've had experience in this kind of cross-agency collaborative body. As noted, you were Chair White's deputy to the Financial Stability Oversight Council, or the FSOC, which was created by the Dodd-Frank Act and brings together representatives of Treasury, the Fed, OCC, CFPB, SEC, FDIC, and CFTC, among others, for the purpose of monitoring certain risks to the U.S. financial sector. Based on your experience, how confident are you, Michael, that this laundry list of U.S. government agencies will be able to work together effectively on digital assets executive orders?
Yeah, I mean, I think that's the key question to all of this, Chris. That laundry list that you impressively read is really quite something. I think a better question is what agencies are not included, and it's probably a shorter list. But if we were to focus for a moment just on the financial regulators, as opposed to ones that have to do with, say, national security, like the Department of Homeland Security or Defense, which really are sort of a separate conversation. The FSOC, I think, started from an admirable place, which is to say these agencies need to talk to each other. They need to coordinate as risks to the financial stability of the United States emerge. And it came out of Dodd-Frank because these agencies, a lot of them were caught flat-footed during the 2007-2008 financial crisis. I experienced FSOC in all of its glory and all of its, I guess I would call it maybe sort of the seedy underbelly of the government, as you see that at the end of the day, agencies can be quite turfy. And what matters most is if you are treading in someone's space, they don't like it. The FSOC functions at its best, in my opinion, when it is truly focused on financial stability risk. So there were moments where I was working for Chair White where we saw FSOC function very well. So for example, around Brexit, there was a devaluation of the yuan that happened. Big global events that have impact on financial stability, seeing those agencies come together, share information, get on calls, have planning, have plans in place as to how they're going to deal with it. That's where they do well. What I don't think FSOC does as well is when you take 10 regulators, you put them in a room and you say, now be a regulator. And part of the challenge to that is it's led by the Department of Treasury, which is a lot of things, but it is not really a regulator. It sets policy, it prints dollars, it collects your taxes, but it's not really experienced in writing rules. And so when it is trying to figure out how to regulate a particular space, it can sometimes its inexperience in that area can show. So I was working with FSOC on the asset management study, which became sort of quite a significant. I don't want to call it a fight, but it became quite a significant event in the life of FSOC and the life of the SEC for sure. In that discussion, what we learned at the SEC is that lots of other agencies had opinions about how the asset management industry should be regulated. The SEC's perspective in all this is they are the regulator of first resort. They've been regulating the asset management industry since 1940, and so their expertise should be deferred to. But yet they had to play ball with some of the other agencies. So you had an asset management study that emerged, and then you had a regulatory plan also emerge where the SEC undertook a bunch of rulemakings to try to address some of the concerns. So that's the history. What can FSOC do in digital asset space? I think it remains to be seen whether they can come together to address the global potential financial stability risks, or does it revert to essentially a turf battle? Obviously, Chair Gensler has been very outspoken and very aggressive in trying to carve out a significant chunk of the digital asset space. But you also see the chair of the CFTC raising his hand frequently and often, even going to his committee of jurisdiction saying, I need more authority. He says the CFTC should regulate the cash spot market for digital assets. That would run in, nobody's really said this directly, but it would run in direct conflict with what the SEC is trying to do in regulating digital assets. So it remains to be seen whether the FSOC becomes basically, a turf battle, or whether they can rise above that and try to figure out the more, global challenging policy issues.
Carla, as someone who may be subject to some or all of those regulators at CoinList, do you agree with Michael that there's going to be this kind of land grab between the regulators themselves, or do you see maybe a rosier picture?
No, I think it is entirely in grab. And I think that, Chairman Gensler has kind of put the stake in the ground because no one else has wanted to take it, honestly, or felt, impassioned to take it. But this executive order gives them a platform now, right, to actually ask for more jurisdiction. And so we'll probably see some fights between the Ag Committee and Senate Banking going on about, who should have jurisdiction here. Can I come back to something that Michael said about FSOC, though? Do you think that they are going to name one of the stable coins as systemically important? And do you think, as I understand it, and you correct me if I'm wrong, but there isn't actually anything else named right now, right? There was always the litigation, and so everybody's just kind of fallen from the wayside. So it would be only the digital asset space that's really subject to this designation. Is that right?
Yeah, that's a great point. FSOC's work during the Obama administration was to name particular companies for designation as systemically important. There are what they call the GSIBs, that the largest banks remain designated, and they can't, based on their size, ever get out from under that. And so they're subject to heightened scrutiny by their regulators, the Fed, the FDIC, and the OCC. But there were designations for, there was AIG, there was Prudential, there was MetLife. All of those have been undone for one reason or another. GE, actually, at one point was also designated. All of those have been undone, either through litigation or because a later version of the FSOC determined to undesignate them. So I think you're absolutely right. One of the things that came up a few years ago when FSOC was looking at the asset management space is, do you designate entities like an AIG or a MetLife, or can you designate activities? Such as asset management. I think what FSOC will be grappling with here is, could they designate an asset class, stablecoins, as systemically important, rather than going after one particular coin or another. And I think one of the things that I learned that is sort of worth bearing repeating, and I also think it's something that the folks who work on FSOC need to remember, is when you're talking about the financial stability of the United States, it's the law of very large numbers. So I believe I could be wrong about this, but my memory is that MetLife, when it was designated, had something like 90 million policyholders, life insurance policyholders, which is, not quite a third of the country, but it's a very significant number. So you can see that there's a lot there. I'm not sure that any particular token other than, even Bitcoin that rises to the type of numbers where you can actually impact financial stability. I do think as an asset class, when you're talking about trillions of dollars across the asset class, that's significant. But as we all know who follow the space, it's not likely that any one event would take all of them down, even though they tend to move roughly in tandem. But I don't know that there'd be any one stablecoin out there that is big enough to pose a risk to financial stability.
So do you think that they might do it by asset class then? Like all stable coins, would that be revisited? Or is that a likelihood?
That's what I think they'll be grappling with. And I think that they will realize that if they start to cherry pick, whether it's a stable coin or whether it's Bitcoin or Ether, you go to any particular coin, it just won't write. It won't be credible to say that anything that happens to this particular asset could actually pose a risk to financial stability. So I do think an asset class based approach is something they'll be looking at. And whether that's because, as you said, maybe there's sort of already momentum behind a CBDC without that discussion even happening, right? Is this something that should happen? It's almost like, well, now that it's happening, let's think about it. So does it try to say, well, if there's going to be a CBDC, there should not be other types of stablecoins out there? Or what is the function of other stablecoins and what risks do they pose to a CBDC? And then the other question could be, are there activities, coming back to activities, that tokens engage in or that digital asset platforms engage in that systemically cause concern, whether it's the flow of funds or the like I said earlier, the anecdotal evidence that they tend to move in tandem as an asset class. Is that something that would be of concern to FSOC? I will say one of the things that I think folks in the industry need to be thinking about is the right way to approach FSOC. Again, one of the things that I experienced is you have a lot of regulators with a lot of deep expertise in their particular area, but that doesn't mean you have people who are deeply expertise about digital assets or stablecoins or digital exchanges. And so I think the industry needs to figure out the best way to educate FSOC because as Chris mentioned, I was on the deputies committee, which is essentially a designee by the principal of the agency. We used to get in a room every 2 weeks in a conference room in the Treasury building and talk about stuff. And I might bring my particular expertise and perspective, and my colleagues at the other agencies did as well. But it doesn't mean that we're all experts in everything. And so the more education I think the industry can bring to bear and get in front of FSOC and explain to them, both the big picture and the nuances behind all of it and the challenges that people like you, Carla, are facing as you're trying to run a compliant business. And where is the friction in the joints, and making them really focus on that point as opposed to, what they might be sort of more, reading in pop culture, making sure they're really well informed about the facts, the current state of play, and the business challenges that you all face.
Just 2 quick points of clarification before we move on. We've been using the term CBDC for those who may not be practicing in this space or interested in more. That is a central bank digital currency. I'm sure, Kurt, we can have a whole episode on CBDCs generally, but if you're interested in reading up more on that. Second point of clarification, Carla, if you want to be our guest podcast host, anytime you may interview any of our guests, and whenever Kurt needs to tap out, I'd be happy.
I'm actually just getting free legal advice from Michael. This is all what this is about. It really has nothing to do with the podcast.
Anybody who has a concern with that, please listen to the very long and quickly spoken disclaimer at the end of this. So.
This is like the third episode in a row, Chris, where you have offered to replace me with one of our guests. I think it means we have awesome guests. I'm going to not take this personally.
I'd be worried if I were you, Kurt.
The 2-year itch, Kurt. We got the 2-year itch here. I don't know if it's going to keep working out.
Yeah. Okay. All right. Okay. So we've got this long list of people coming together, but let's just think about the FSOC in particular, and they're going to be sharing their expertise and talking about potentially ways to move forward with rules or regulations or potentially designations in this space. It seems like something is going to happen here. Maybe it won't be as unified as President Biden would like. Maybe some of the agencies decide to go it on their own, but I think something's going to happen. And Brett Harrison, who is the president of FTX US, sort of alluded to this in an interview with Neil Cavuto on Fox just days after this executive order was released. And here's what he had to say, quote, "Some amount of regulation is important to allow institutions to come in and feel confident in being able to put their money into this emerging space," end quote. I think what he was imagining is that if we can end up with a regulatory framework where institutional investors feel comfortable, that more money will start to come into digital assets or into the cryptocurrency space. But I think at the core of that is this notion that some amount of regulation is important. And so my question for you, Carla, let's get the in-house perspective. Do you agree with that?
I mean, absolutely. I mean, I don't want it to go unnoticed that there is regulation in this space, right? I think Mr. Harrison's probably saying that there's no overarching scheme, and he's right about that. But there's regulation. The CFTC has regulation over, or has regulatory authority over the spot commodities markets, and that's what most of the U.S. exchanges operate under for manipulation and fraud and that type of thing. Lots of states involvements there for money transmitters, and then also I think there's already, a lot of institutional money in the space. Is, people are adopting it more and more, especially on the more, I guess, tried and true type of assets, Bitcoin and others. But all that being said, I agree that more clarity is going to bring, more legitimate players into the market, bigger dollars, and that's going to be better for everybody. So yeah, I think we do want some regulation. The trick is the balance, right? So we have so many projects that come into CoinList, and growing their communities and their users is so important. How do you put regulation around these sometimes very very tiny teams, so that there's this idea of, okay, this is regulated, this is protected, you can feel safe about transacting or being on this platform without actually killing the idea of the project and killing the technology altogether. And I don't know the answer to that, but that is the challenge and the balance that you kind of have to strike.
At some point, is it too much, right? If we've got, the CFPB and the FTC and the SEC and the CFTC and the FDIC, and they're all coming in and potentially putting out their own guidance or rules, when is it too much regulation?
It's too much right now because there's no clarity, right? I have to kind of always figure out, am I more in the SEC space? Am I more in the CFTC space? Which space am I in? Or, do I just want to jump shore altogether? There's too much right now because it's so unclear. I don't know what I'm supposed to be operating under. In my perfect world, and we might get to this later, but in my perfect world, it's the CFTC that kind of takes hold of this area. We already operate under their regime. I think they've been very intentional and deliberate about the enforcement actions they're bringing for just very egregious type of activities. And, Michael maybe has a different view, or I'd like to hear his view on that. But they feel like an agency that we in the industry could work with. So even if it's some kind of like light touch registration regime for the CFTC, I'd love to see that happen. And again, it's not that we oppose regulation, but the way that it's happening right now isn't working.
Michael, what's your reaction to that, or what's your view on kind of getting the right touch from a regulatory standpoint?
Yeah, I mean, the challenges that Carla's describing obviously are not unique to her business. It's something that we hear across our client base. Chair Gensler came out this fall at an event of securities professionals, SEC enforcement lawyers, and criticized the SEC Defense Bar by saying, do not enable these various platforms to exist outside of the regulatory regime. You should be counseling companies to come in. You should be counseling companies to come in and talk to us, and they need to come in and register, and then everything will be hunky-dory. I don't think that was a very fair criticism to level against the bar, but I also think it's not recognizing the challenges that Carla is talking about that we hear from lots of participants in the market. They are clamoring for clarity. I don't think market participants are looking for sort of an exhaustively, overly constrictive regulatory regime. But at the same time, I can't think of a client who says, I think this should be completely unregulated. I should be beholden to nobody, and there is no role for regulation. That's not what's going on. What you have are businesses that have really novel, exciting projects that want to do things the right way and would like that, but they need to know who their regulator is, what the expectations are, where are the lines in which they're operating. And Carla mentioned that the startup culture. If you want to start up a social media company, you can do it tomorrow in your basement. And as we're obviously learning, social media can be extremely harmful in some cases, and there's no regulation over that. But yet, the promise of digital assets, from whether it's financial inclusion or speeding payment rails, or any number of potential areas, is enormous. And yes, it involves money at its base, so it does need to be regulated. But the regulation needs to be sort of within the context that allows these companies to flourish and grow. I should add, we talked a little bit about FSOC, and it has to do a study. I didn't actually count up in the order how many studies are called for, but it's a lot and it's overlapping. There is another piece of the executive order, I think it's section 5B, that says that the Secretary of the Treasury, in consultation with the Secretary of Labor and the head of other relevant agencies, including the FTC, the SEC, the CFTC, the federal banking agencies, and the CFPB, shall create a report on the implications of digital assets on financial markets and payment system infrastructure for consumers, investors, businesses, and equitable growth. So a small topic that should be a very easy report for them to write. And they have 6 months to do it, and the government will have no problem hitting that mark. But what are they going to do with all these reports? Who's reading them and then decides what to do with all of these reports? I mean, that's sort of the next question. And obviously, we haven't touched it all on the other branch of government that's out there, which is Congress. I mean, to Carla's point, this is the executive branch trying to move the needle. But is the answer executive regulation, or is it a legislative solution where Congress steps in and defines digital assets into various buckets and decides if you're doing this type of activity, you're regulated this way. If you're doing another type of activity, you're regulated that way. Or, as there's been plenty of chatter, you stand up a new regulator. You come up with a statutory definition for a digital asset, and you build a ground-up regulatory regime for trading, for exchanges, for issuance that accounts for what these things are, rather than trying to shoehorn these novel asset classes into what are very, in a lot of cases, very old regulatory regimes that just sort of don't work on their face.
Yeah, I think that's absolutely right. It will be interesting to see how this executive order is used, especially as the election is coming up, right? I wonder, will Congress be using it to kind of go against the administration? Will that get traction? What impact will that have on the different agencies, if any? And then this idea of having, our own SRO or our own regulator, I love, but so many people hate it, Michael. So I wonder, are you hearing the same or not? Like, I'd even love an SRO that sat underneath the SEC and the CFTC as kind of joint jurisdiction. That would be fine. Somebody that really understood this asset class is what's needed. I can't get any traction whatsoever.
Well, it's certainly easier to use existing regulators than it is to stand up a new regulator. And so I'm sure the backlash on that comes both from those within who work at the government and say, no, we've got this, right? You've heard the SEC says, oh, no, there's a case from 1946. It's called the Howey test. It's perfect. It works perfectly on digital assets. It's very simple. And then you also have, I'm sure those within the industry that sort of say like, well, this is a devil type situation. You stand up a new regulator, what's that going to mean? There's not a lot of history to look back on in terms of new regulators being stood up. You do look at the CFPB. That's a new regulator following Dodd-Frank. I'm not in a position to sort of judge the CFPB's effectiveness or not. There's been a lot of challenges to its structure that have come and spent a lot of time just sort of litigating its own sort of right to exist. But I actually, quite frankly, I agree with you. I'm in favor of either a new regulator or, a good point, an SRO that is sort of jointly overseen by the SEC, the CFTC. And I think I think the role for legislation could simply be to define things. So to the extent that the dynamic in Congress is the last thing that Congress wants to do is create a new agency that requires new funding that will take years to roll out new rules. You could legislatively define things and make it clear who the regulator is for which activities, for which asset classes. And I don't think it would be all that challenging to create legislation that defines a digital asset in a way that allows them to be issued and traded without running afoul of all of the federal securities laws.
I think we found our new careers, Michael. We're going to stand up this new regulatory agency. I think. Yeah.
That's exactly it. That's right.
Breaking news on the Insecurities podcast. That's what we love.
Yeah, my phone has not been ringing off the hook seeking my input on this question.
Well, it will soon. It will soon, as soon as this airs. All right, Michael, you mentioned a moment ago that the executive order calls for a bunch of reports. And I think, Carla, you spoke earlier about some of the deadlines that are being imposed. They're all over the board. Some things you have 180 days. Some things you've got up to a year. In any event, I think the deadlines are a little tighter than what might be reasonable. I guess my big question is, after all the reports have been submitted, what do you think, Carla, what do you think will be the outcome? What is the upshot of this executive order?
Yeah, I'll just comment on your 180 days. It's funny because in crypto land, 180 days is like forever. And so you're just like, this seems really aggressive. And so it's kind of interesting just to hear the two views, because everybody's like, what's going to take them 6 months to look at in my world, right? Every day. And I just realized 180 days is nothing in regulatory land at all.
Mm-hmm.
And especially when you're talking about these really large, I mean, Michael read the one topic and I was like, I mean, oh my gosh, it's going to take forever. And then you have all these different agencies come together or try to come together. It's going to be really challenging in 180 days. So, yeah, I just think I think we touched on it a little bit. I think that the executive order is going to culminate in some pushes for rulemakings. I think we're going to be looking at a ton of proposals coming out of this, probably for the next, I don't know, 5 years even, something like that. I think that really to move in this space, we're going to need legislative action, but I think they might use the executive order and the studies that come out of it to help inform them to do that. And that's what I'm hopeful for, actually. These are going to be heavy on consumer protection, but, it's very, very clear. And so if we want this industry to kind of continue on in the U.S., I think legislative action is going to have to move for that. And then I'm just curious to see what does happen around the U.S. issued CBDC, and then also whether FSOC particularly is going to designate that stablecoin activity in general, or USDC or one of the stablecoins as something that's systemically important. I find all of those super fascinating and something that could be real.
What do you think, Michael? Are we going to get speeches and policy pronouncements, or is this all going to lead to some kind of legislation or regulation at the agencies?
Yeah, I mean, I agree. It's sort of an exciting time in the industry in general, but particularly with this executive order now forcing agencies to focus in on it. Those reports, I'm gonna guess here. I'm gonna break the story, Chris. They're not coming out in 180 days. That's my prediction.
Oh,
that's my prediction.
You sounded so confident earlier.
Having seen what it takes to create these, that's mission impossible. But I think
That's right.
I think if the agencies think about this process and how they can be most effective, the most effective reports are going to be ones that have specific, granular, and operationalizable recommendations. So we saw before this EO came out, there was the President's Working Group came out and did its own report on stablecoins. And that's the Treasury, the SEC, the CFTC, and a couple other agencies. And their recommendation was essentially Congress should look at it, FSOC should look at it, we should all think about it. If that's what these reports say, is essentially they're reports saying people need to think more about it, or XYZ agency should think about regulation, I don't think this exercise winds up being very meaningful. But if the agencies actually say, how do we actually solve the problem that's been put in front of us in a thoughtful way? And so the report is more of an outline or a pathway, a prescription for action. Then I think you could see something moving forward, whether it's, okay, here's the rule that this agency will write on this particular topic, or here's something that a congressperson could pick up and run with as they're thinking about legislation to say, well, look, we've read this report, and if I'm crafting legislation, I need to think about navigating the channels in this particular way. So we'll know more as these reports kind of sort of roll off the presses, so to speak. And to Carla's point, the challenge is not just the inner workings of government getting them done quickly, but this is a space that evolves so quickly. If I think about the work that I'm doing now, the conversations I have with our clients now in terms of what the emergent issues are versus what we were talking about 6 months ago or a year ago, it's incredibly different set of issues. As Web3 continues to evolve and the technology evolves and how people are thinking about it, the conversation could be totally different by the time these reports come out. So that's something else that the regulators are going to have to grapple with is staying current and staying relevant.
I think you both are being way too measured and practical in your expectations. So I want to kind of get both of your takes. Carla, we'll go to you first. What's your ideal outcome from this executive order, with these reports or regulation? What do you hope for? What do you think is the best potential?
Yeah, and I think I pretty much already said it. I would love one regulatory scheme. I would love it for it to be the CFTC. In the perfect world, it would be a regulator that really, a whole separate regulator that really understood the digital asset space. That's not happening. But that would be my ideal
Until
outcome.
That phone rings.
Until Michael sets it up, it's not happening. That's right.
Michael, same for you. Are you being the czar of the SRO over digital assets? Is that your ideal outcome, or do you see some wiggle room here?
Woe to that person. Talk about a challenging job. I wonder if that's where it heads to, is sort of almost a crypto czar, or a digital asset czar who has to sort of drive this. But I do think, I agree with Carla. I think it's a legislative solution that ultimately solves this, not a regulatory, not an executive branch solution. And perhaps that's really the ideal outcome of these studies, is simply shining a big enough spotlight on it that it almost shines a spotlight on the problem. You can't have 15 different agencies agree on how to regulate an incredibly complex space. Recognize this really is novel, and it's something that is new that requires its own legislation. Again, to sort of bring it back to, I mentioned social media before. You talk about the internet, and there's a lot of discussion about the statutes that protect internet providers and content providers from being sued. That was obviously bespoke legislation that came out years and years ago to allow that space to try to flourish. And now many years later, people are questioning the wisdom of that, and that's all sort of makes sense as an evolution. So, is it the same type of situation? Can the government, whether it's the legislative branch or the executive branch, recognize that it's time for everyone to sort of sharpen their pencils and think about how to deal with this as a new asset class and as a new space in our economy, and not just try to shoehorn it into existing frameworks?
And Michael, do you think that by coming together and really talking about this in an intentional way, that it would actually push some of the agencies to get ahead of the game and start making rule proposals? Like, I could see, because there is that kind of like tension for jurisdiction, the SEC particularly being aggressive and like going ahead and just throwing something out there if they know the Fed or somebody else is going to do something that they don't like, for example.
Oh yeah, absolutely. I mean, that's what happened with the asset management study, is that the program of rulemakings was in part recognition that if the SEC didn't act and propose some rulemakings, somebody else was going to act for them. In other words, an FSOC study that really sort of criticized some regulatory gaps in the regime. So I think you're right that a lot of the agencies, this will be a moment for them to focus and kind of realize, well, we need to show that we're doing something here. And so I'm sure, does it push the SEC to rulemaking? Probably. CFTC, do they increase their push for statutory authority? Probably. But what about some of the other agencies that have been quieter? Do they start to look around and say, listen, if we're not being proactive, we're going to just get elbowed out of this space. And so we need to have our own thoughts on this. Maybe that makes your job even harder.
Yay.
Well, Want to thank both Carla and Michael for coming on. We've really enjoyed the conversation. I think you've given regulators as well as those folks, listeners interested in this space, a lot to chew on. Any final thoughts, Carla, you first, before we sign off for the day?
Yeah, I mean, I hope that regulators will keep an open mind, about a true open mind, right? I think so many regulators have just kind of written this whole space off as fraud. And when they do that, it means that they aren't willing to put in protections for the people that aren't fraudsters. They're not actually helping consumers who are going to be in this space no matter if there's regulations or not. So I hope that that's the case with this executive order. And as we progress, this technology is not going to move backwards. It's only going to move forwards. Yeah. That's it.
Great. Michael, parting wisdom for our listeners?
That was very well said. I will, as I had done years ago, I will rely on Carla's very excellent words.
Well, thank you both for joining us this week. We really appreciate it.
Thank you.
Thank you.
Thanks for joining us for this episode of the Insecurities Podcast, and a special thanks to our guests, Carla Caraveau of CoinList and Michael Liftik of Coin Emanuel. As always, we want to hear from you regarding your thoughts, comments, and topics for discussion on future episodes of Insecurities. Please use the hashtag InsecuritiesPod on Twitter or LinkedIn to join the conversation. You can find me at EcomoffCPA.
And I'm at Enforce_update.
Be sure to subscribe, rate, and review the Insecurities Podcast wherever you listen. Be well, everyone, and we'll see you next time.
Thanks for tuning in.
Thanks for listening to Insecurities, a podcast from PLI, the Practicing Law Institute. PLI is a nonprofit provider of authoritative professional services training and continuing education. In an increasingly complex business environment where intricate corporate structures reign, Insecurities can help you make sense of it all. A special thanks goes to the producer of Insecurities, Daniel Peinitz, as well as hosts Chris Ecomoff and Kurt Wolf. For more information about PLI's SEC Institute, or to view hundreds of hours of fresh and relevant on-demand programming covering changes within the securities sector, visit pli.edu/membership and sign up for a privileged membership. These recorded materials are designed for educational purposes only. This podcast does not constitute legal, audit, tax, consulting, business, financial, investment, or other professional advice, and it does not create an attorney-client relationship. Please consult a qualified professional advisor before taking any action based on the information herein. Furthermore, the views and opinions expressed in this podcast are solely those of the individual participants. These views are not the views of the hosts or their employers. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission from PLI.